May it please the court, Mark Tinker on behalf of Gustavo Zapata and Nellie Betrago. I'd like to reserve 5 minutes.
Okay.
We have 2 issues for the court today, and jurisdictionally we're here because the trial judge in part granted Feaster a partial motion for new trial as to future non-economic damages, but that the court having jurisdiction also has jurisdiction to look at the entire case, and I think the issue that makes sense to be addressed first is the denial of our motion for new trial, because if that's granted, it makes the other issue moot. So they'll get their partial new trial along with the new trial of everything else. The grounds, the basis for the motion for new trial was that this is a 4-car accident. My client struck a vehicle, pushed it into another vehicle. That vehicle ultimately hit Ms. Feaster's vehicle. The trial judge allowed Feaster during trial to put in evidence and argument related to all of the other impacts that occurred prior to the one that ultimately struck her. And obviously I think there's no basis for relevance for all of these other impacts. It doesn't matter how hard Mr. Mahoney, or I guess it's pronounced Mahoney, was struck by my client. It doesn't matter how hard he hit Mr. Milburn then. The only relevant fact is how hard Mr. Milburn ultimately hit Feaster.
So are you saying the plaintiff would have needed a biomechanical engineer to have testimony as to the force of impact traveling through those cars to hit the plaintiff and yet not cause property damage but still have significant force?
I think that's part of it. I think...
Well, that kind of a yes or no?
Yes.
Okay.
Well, no, I don't think it's...
Because you've got a problem with the Wall v. Alvarez case? Where that's exactly what the trial judge required and it was reversed on appeal?
Well, that's why I'm saying no, I don't think it's required. I think one of the things that we're looking at is if they were going to say, well, it's relevant in order to just show how all of the forces came together, then I think there would need to be an expert to talk about vehicle weights and how forces are applied and momentum and all of those things. But I think the way it was used here, the only stated relevance is we wanted to show how hard she was ultimately impacted. And none of that stuff has any relevance. It wouldn't matter if my client was driving 90 miles an hour or 5. If he slams into the back of the vehicle at 90 miles an hour and all the crumple zones and everything do their job and all these other cars and the ultimate impact to Miss Feaster is 5 miles an hour, or if he hits the rear vehicle at 5 and nobody has their feet on the brakes, they're all in neutral, and it still ends up that she's hit at 5 miles an hour, that's the only key fact, is how hard was she hit. And I think what's telling, and when this evidence was put in and these photographs were put in, that's the question that Feaster never asked. Asked Mr. Mahoney, how hard were you hit? He described it being an incredible impact. He described being knocked unconscious, having to be lifted out of his car.
Well, that could have been brought out on cross, right?
I don't think it's relevant, whether it's on direct or cross, how he was injured.
But the trial judge apparently made the decision that all of this evidence, the photographic evidence, all went to weight, not admissibility. Let the jury figure out if it had any probative value, because it's all happened as one series of collisions. There was, I guess, 3 different impacts, correct?
Correct.
4 cars total.
As to Ms. Feaster, she only felt 1 impact. So that was the relevant one. It's not a situation where she was hit and then...
basically your position is, we just want to see this one little impact with no damage. We don't want to see the stuff with the bad stuff. Don't let the jury see that. Just let them see this end result, and nobody will believe this person could have possibly been injured.
Well, I think...
Isn't that depriving the jury of evidence?
No, because I think the end result is the only relevant part. And I think what you just said there, the judge said, well, let's put it all in and let the jury decide whether it has any probative value. Well, what you're saying, whether it has any probative value, that's whether it's relevant, and that's the judge's job to decide, is this admissible? Is it relevant?
You had a pretty good judge in this case. It seemed like the judge had a nice discussion. He went into a lot of detail. There wasn't really anything that wasn't argued. The attorneys did a good job, and he just made a decision, a judgment call that could have gone either way.
And I don't think it could go either way, because there's no way that what happened to Mr. Mahoney and his injuries is relevant. And then if you look at what happened as soon as that testimony came out, the jury, obviously, the argument was made in the answer brief, well, this was just a small part of the trial. Maybe it was the beginning of the trial. It set the stage, and the jury immediately started asking questions. What about your injuries, Mr. Mahoney? Did you require extensive medical treatment? The jury got sidetracked into looking at, this was an incredible beginning impact.
Counsel, there was medical testimony which established that Feaster had sustained permanent injuries. Why isn't that relevant as to so that the jury could properly evaluate the severity of the collision and then determine whether that had any bearing on the medical testimony, which established that he had permanent injuries, or she had permanent injuries. It seems to me that when you present your argument, you're ignoring the fact that there was this element of permanent injuries that perhaps a jury could evaluate in light of the totality of the accident.
Well, I think what I'm trying to get at is absolutely the jury is entitled to see the ultimate impact to decide whether it's, how that plays into her claim of permanent injuries. The issue is how hard my client hit Mr. Mahoney doesn't answer that question at all. It has no bearing on it.
Well, it could. If she's claiming permanent injuries, and if it's an accident that the jury concludes couldn't result in any kind of serious injuries, then that might be relevant then.
But how hard my client hit Mr. Mahoney would be relevant to whether Mr. Mahoney had permanent injuries. How hard Mahoney hit Milburn might be relevant to whether Mr. Milburn was injured. The only question relevant to Ms. Feaster is how hard did Milburn hit her? And that's the question that Feaster's counsel never asked. We went through all of these other ones because they made for dramatic pictures and dramatic testimony. Never once asked Mr. Milburn, how hard did you hit my client? That came out on cross-examination finally, but that shows that this was being used to set up the jury to prejudice them and to say, look at how, what a great collision this first one was. And in closing argument, his car was blown up and the trunk was pushed into the back seat and all of these things. It was an incredible impact. But that has nothing to do with, when you look at Ms. Feaster, how hard was she hit? That has no probative value towards that ultimate question. And that's why I think, this was something that set the stage for the whole trial. I think on this record, it's evident that it did cause prejudice. Even the trial judge noted
it seemed to really confuse the jury. I mean, I think it was designed to confuse the jury.
I agree. I think, like I said, the jury immediately started asking questions about how hard what was your treatment, Mr. Mahoney? Were you injured? Did you require extensive treatment? And I think as far as confusing the jury, one of the big things that obviously you worry is going to get in jurors' minds is they're wondering, well, why is Feaster the only one suing? Was she the one that was, more seriously hurt in all of this? Did they settle with everybody else? Is there enough insurance money to go around? Those are the issues that I think infect the jury's mind. And we're looking, again, I go back to, since liability was admitted, we can tell the jury this was a 4-car accident and everything, but the only relevant question is how hard was she hit?
Well, the relevant question is how was she entitled to permanent injuries, permanent injury damages, wasn't it?
Correct, and that's something that the experts could talk about. That they could show the pictures of, well, here's how. Look at the damage done to her car. She had a dent or whatever she had on the back of her car. That supports her claim that this was a hard enough impact as to her. But it's not relevant how hard Mr. Mahoney got hit or Mr. Milburn got hit. None of those things speak to her ability to get permanent injuries and how hard she was hit. And so all of these other things, I think, just confused and prejudiced the jury. And especially on this record, if you look at what Judge Shames said during the post-trial motion hearing, he's deciding whether this, the new trial was, if he was going to grant one, if it was going to be on all issues or just the future non-economic damages. He said to the plaintiff very candidly, he said, well, I don't know if you really want a new trial on all issues because you kind of, you'd be counting on lightning striking twice here.
But he thought you guys might be doing some sort of ongoing mediation, which you ultimately, both sides said they weren't. So it was up to him. They're waiting for him to make a decision. He took it under advisement, and he prepared the order that's now on appeal.
Correct.
Okay.
That's really it as far as the first issue. Unless the court has any other questions on it, I think it's as simple as looking at, was this relevant? I don't believe that it was. Was it prejudicial? I think absolutely. Just on the face of looking at the pictures that I provided for the court and what the jury did and what the judge said as a result of it. The second issue is, I think, even more straightforward. The judge said, well, because there's a permanent injury finding, I need to back up, actually. The judge's order doesn't specify any grounds, which I think makes it defective, but we haven't really made a big deal out of that because the motion for partial new trial only raised one ground, so I think it's inherently what the judge did. But the argument was that because there's a permanent injury and future medical expenses awarded, that there has to be future non-economic damages also. The Supreme Court says no, that's not the case in Allstate versus Manass. And really always...
There's two Allstate cases with the same name.
One was the district court, I believe it was in the 4th district, is where the 4th district said, yes, there does have to be future non-economic damages in this situation. It went to the Supreme Court and it kept the same style because Allstate was the appellant or petitioner in both. And the Supreme Court said, no, that's not the case. The only thing that the court does is look to see, was there something that justifies the jury's decision? And in this case, what the response was, well, there's all this medical testimony, and this doctor said that, and this doctor. It doesn't matter how much, for them to say our evidence was better than your evidence. The only question before a judge can come in and essentially veto a jury's decision is, was there something that the jury could have hung their hat on in this case? Is there contrary evidence to everything that they've talked about that the jury can say, yes, we think that future economic damages are necessary, but there's no need for future pain and suffering damages. And that's evident in this record, actually, from Feaster's testimony herself. She said, I'm getting these epidural steroid injections. They're great. They work fine. They give me relief. So the jury could say, yes, we're going to pay for those injections to continue in the future, but they alleviate your pain. So there's no need for future non-economic damages. I believe he was a pain management specialist who's providing the injections, said the same thing, said they seem to be giving her great relief.
But they'd say if they didn't work, surgery would be required.
Right.
So that was a little bit speculative.
Correct. But he said as far as what we're doing right now, there is no surgery required now. Everybody agreed to that. And she's getting the injections. And he said as far as what we're doing right now, that seems to be working great. So the question is, was the jury justified in saying, yes, we're going to pay for those things going forward, but no, there's no need for future pain and suffering damages? And that evidence is there in this record, and it's not for the judge to say, well, I would have disagreed with that, I'm going to veto the verdict, the proverbial 7th juror with veto power. And I think this court, looking at it, there is evidence in the record, again, the same thing, that the jury was justified in what it did. So I believe that the court should at the very least reverse the order granting the partial new trial. Unless the court has any questions, I'd reserve the rest of my time.
Well, just to clarify,
Yes, sir.
you want a reversal on that order, but not because the order is defective on its face for not having findings or anything like that. You don't want to send it back for more findings.
I think that would be pointless. I think on this record, there was only one ground raised, so that's what the judge relied upon. I think sending it back to have him say that and then it's come back again would be pointless.
Okay, I appreciate that.
Thank you.
Good morning. May it please the court, Robert Heyman for the appellee, Bridget Feaster. Regarding the appellant's argument about the admissibility of the other evidence of the other crashes, what you just heard was a very good closing argument, and that's what was given to the jury at the trial in this case. This is a case where I think, once again, they better be careful what they're asking for. I think they're standing for the proposition that if liability is stipulated to, then anything that happens prior to the collision between the plaintiff's car and the car that immediately struck it is irrelevant. And that's not...
I don't think that's what they've argued at all. What they've argued is that the severity of the prior collisions that didn't involve your client whatsoever had no bearing on the amount of impact that she received when in the accident. And the severity of the impact to her is relevant in considering whether she did in fact receive permanent injuries from this accident.
Okay, I have two responses. Number one, it is relevant. The jury, my position is the jury should have heard the entire,
How does the severity of the impact to any of the other cars prove the severity of the impact to her car? How can you tell me on this record where it shows that there's a relationship?
It shows the force that was placed upon that van that ran into my client's vehicle. I mean, let's face it, there are times, this is going to be very case specific for the appellant. There are other times, if they had a biomechanical engineer and an accident reconstruction expert, you're darn well sure that they would have used all of those impacts to show that by the time the car that struck my client was moved forward, that it would have been a minimal impact. What they're trying to do is basically just isolate that one impact, when in fact it is a combination of those forces. Lay witnesses can give opinions. We didn't have an opinion from a witness about the severity of the impact, but I think the jury should be given the same ability.
Well, I don't think that there was any contention that it wasn't relevant, the severity of the impact to your client's car. That's not their argument. Their argument is that's the only thing that's relevant.
Well, I think they make a 403 argument in their brief. They're saying that if there's any relevance, the prejudice outweighs whatever relevance there is. And I think it's also relevant to just show the context, Judge. And the cases that I've cited say exactly that, especially in multi-vehicle accidents. I cited White versus Westland, which I'll just read right from it. In most instances, evidence describing the details of an accident is logically relevant and admissible, even where liability has been admitted, to place the extent of injuries suffered by the plaintiff as well as the degree of pain endured in the proper context. So, you know, they're concerned about the questions that were asked at this trial. The jury asked 2 questions. They asked, number 1, how many vehicles were involved? And they asked, number 2, did one of the occupants of one of the other vehicles need medical testimony? Needed medical treatment. Excuse my voice, I got 20 minutes and that's about it today. And the first question was properly answered. There were 4 cars involved in this collision. The second question, where they were told they couldn't answer. Now, there will always be those types of questions, but consider the circumstance if the other collisions were not mentioned. What kinds of questions would there have been at that point in time?
I don't think their argument is that they shouldn't have been mentioned.
I get it. I mean, it's a question of the severity of those impacts. How is that relevant to the impact with my client's vehicle?
Right, exactly.
Okay, and I'm suggesting.
So when they show a car where the back seat's been shoved into the front of the vehicle, and that's not what happened to your client's car at all, not even close. How is that probative of the force of the impact to your client, and not prejudicial when they see this car that the back end is collapsed?
This is a chain reaction accident. We have, without that evidence, without
right. But how did you? What was your evidence that tied the force of that initial impact into what force your client felt?
Well, what I was left with was the driver of the van testified. I had my foot. I'm driving a van. I had my foot on the brake, and all of a sudden I'm propelled a number of feet forward into the vehicle in front of me. It's a 4-car accident. I mean, I would suggest that it was relevant to show the force that was necessary to move that van forward. And that gives it the context. I think the case law is very clear. The jury can get the context. I don't know if it might have been relevant to the case I just heard the court listen to, but the Black case that I cited in my brief, that was a case where a suspect was questioned wearing jail clothes. And it was found to be relevant to show the context of the defendant's statements. So I'm suggesting, number 1, it gives the jury the context of just what happened. And also, it is relevant to show the force that was placed upon that van driving it into my client's vehicle. And like I said, the shoe is oftentimes on the other foot. A case that I did not cite in my brief, but was in my response to their motion for new trial, was Allstate versus Kidwell. And at Kidwell, it was a multiple car accident. And in that case, what Allstate wanted to do was introduce photographs of the vehicles to show minimal damage. Well, the trial court said no, and they were reversed on appeal. So once again, you know, I'm assuming in this case what happened is they went forward without thinking the need for any expert testimony to describe the severity of the accident. My suggestion is the jury needed to see that just to get the context of what happened. And number 2, they could have made their own opinions as to how hard that van was hit and caused it to ultimately strike my client's vehicle. I think that's the relevance, and it's also relevant for the context of just the entire accident itself. Now, counsel also in their brief, they argued that I made this a feature of the trial. I think I went through in my brief and I tried to outline to the court that this was not a feature of the trial. It was a minor portion of the testimony. It was only a scant number of pages. That the strength of this case, quite frankly, after hearing the facts of the accident itself, came from the medical testimony. That there was my client had for years been asymptomatic, that the diagnostic tests indicated prior to the accident that she did not have the problems that she had after the fact. So this is not a case where I was showing blown up photographs ad nauseum to this jury in order to inflame them. I would suggest that this trial took a week and that there was much medical testimony that established that my client did sustain a permanent injury, and it was related as a result of the medical testimony of the 3 doctors that testified in the trial. I mean, I think, getting back, Judge, to your question, I think you know, the bottom line is the jury had a right to hear and see what happened. Judge Shames indicated in his response to the defense's concerns about all the questions that would be asked. And he said, you know, let's give them what happened, and then they can figure out whose version of the events is correct. And I think that gets down to the bottom line. It is not, I mean, if it's relevant at all, it should come in. If it's relevant at all, and if it's not overly prejudicial. Is this overly prejudicial to show a number of pages of testimony? And I was limited in the amount of photographs I was able to show. I only showed one photograph of each car, and that was it. And they're asking to overrule Judge Shames. I mean, you know, at trial, courts are given great discretion. And I would suggest that, once again, the trial judge should be afforded that same discretion. And if you know, I don't see evidence in this record that this was an overly prejudicial explanation of the collisions of the other vehicles that somehow overpowered the jury, so they felt sorry for my client and ignored the other testimony. You know, the medical testimony was just about, you know, it was completely consistent, and as I put in my brief, even the defense expert witness was helpful to establish the permanency of the injury. So I think that, you know, in this case, the court has to look to the entire record in determining whether or not a 4-3 argument is appropriate. I would suggest it's not in this case. This was certainly something to inform them of the nature of the collision, but it wasn't something that was an overriding theme of the case as pointed out by the defense. Now, it wasn't mentioned, but I'll just describe in the brief. There was some description of, and I think the reference was made to Judge Shames's comment about, yeah, I better be careful what I ask for. They argued in their brief that somehow the offer of the proposal for settlement somehow makes it appear that I was shocked by the nature of this verdict. In the real world, I left that mediation from Allstate when they had offered $35,000, and I would have guaranteed that there was no way under the sun that they would have paid me $45,000 at least within 30 days of my offer. That was in no way a characterization of my belief of what this case was worth, so I think that should be discounted. Now, as far as the trial court's ruling on the granting my motion for new trial on the issue of future non-economic damages, I mean, Manasseh is correct. I mean, what the 4th District said was it was an automatic reversal. I think the Supreme Court said you need to look at all the circumstances. And in this case, we're given my client who has been undergoing treatment for about 5 years. That most recently, up until a couple of days before the trial.
The problem with the transcript is it looks like the judge thought he was required as a matter of law to give a new trial on that future damage issue. Do you have a
that was part, and I admitted in my brief that I didn't mean to misrepresent that. I mean, and I think, quite frankly, jumping ahead, I think what I had suggested in my brief is correct. This needs to go back to Judge Shames on that issue for him to enter a new order, giving his reasons for the granting of the motion for new trial.
And if he comes up with, I thought I was required as a matter of law to give a new trial, but not because I believe there's enough evidence where the jury must award future damages.
Well, if he says that, then I'm done. Then I'm done. I mean, I think he needs to follow the Supreme Court.
So it's not necessary, it could generate another appeal, but you're kind of conceding that you'd be satisfied.
I think the appellate courts all the time send
because he took it under advisement. So are we only limited to the transcript? We don't know what he was thinking off the record. No, so it wouldn't be fair to your client to say that we shouldn't send it back for more findings because he was only thinking the wrong law applied.
I think it should go back, and I think he needs to explain on the record. If he says he felt it was mandatory, that would be an error. I think that he needs to make factual findings and indicate that he was using his discretion based upon the evidence in the record. This is a woman who, and you know, this is a woman who had been received treatment for 5 years, chiropractic, other conservative treatment. The jury saw a video of her, the injections that she received in her hip. The needle was that long. It was so, apparently, the defense thought it was so inflammatory they did a motion in limine to try to exclude it. She would be required to undergo these for at least into the indefinite future because the doctor said they worked. The doctor didn't say they didn't hurt. And obviously the defense thought it was inflammatory enough to try to keep it away from the jury to even see this 3-minute video. the cases that are cited that reverse a trial court's granting of a new trial on the issue of future non-economic damages, there were problems in those cases. It was a case where the plaintiff's attorney, Manas is the case in Manas. She was only in the future. The plaintiff only indicated through the evidence that she was going to need chiropractic in the future, that it didn't hurt. That's quite different than the case here. She's going to need these injections for perhaps the next 20 years, which is based upon the jury's verdict. I think that's how they scheduled it out. These were painful injections, and she would, if they didn't work, she was going to need surgery. I would suggest that and also, let's face it, there were the other issues in her life that would never come back. She was a basketball coach. She couldn't exercise. She couldn't do things around the home. These are other things that go to the non-economic damages finding. But I think most importantly, getting stuck with that needle every month for the next 20 years was certainly enough evidence for the trial judge to take a look and say, listen, the jury gave her prior pain and suffering, $25,000 for the past 5 years. I asked them to calculate it $5,000 per year. It's always a difficult thing to try to quantify. But they gave her $25,000 for the previous 5 years, so they followed my calculation. And for them to not give an award of future non-economic damages for the same set of circumstances that they gave past non-economic damages was against the manifest weight of the evidence. And that's my suggestion, as I argue to the judges, should be the basis for granting a new trial on the issue of future pain and suffering.
All right.
You know, that's what I have. I mean, in closing, the court needs to go back and put themselves in the shoes of the trial judge. We have a multi-car accident. I understand maybe we could have made the announcement that this was a 4-car accident, and maybe excluded the other evidence of the collisions in the case. My argument is that jury needed to see those other collisions to see just how much force was left when that third car hit the van that drove it into my car. We didn't have an expert. We didn't need one. Even a lay person could have rendered an opinion. And I'm suggesting that the jury should have made that same opinion. I mean, not to be trite, but what they basically want to do is, I mean, they want to shorten up Shakespeare's Romeo and Juliet and say, listen, the two star-crossed lovers drank poison and died. And that, in this case, would have not permitted the jury to see the entire circumstances of this case. And it would have been problematic, I think, from an evidentiary standpoint. I mean, it would have been, quite frankly, probably something I could not have appealed, because in my belief, it would have been within the court's discretion to make that determination. And the judge did it in this case, and the judge's ruling should be upheld. I thank you for your time.
Okay, thank you.
I think on the primary issue, the argument's been made that all of these prior things were relevant to show the force that was applied to the van, to the back of the van. And I think that's why I gave you a yes or no answer to your question about the expert early on, initially, Judge Valenti. I think if we're talking about showing the forces applied to the van so we can tell the jury how hard...
Was the van ultimately totaled?
I believe that there was testimony in the record that it was, yes.
That was the vehicle that hit the plaintiff's vehicle.
Correct. But the issue is...
The impact that the van made to the plaintiff's vehicle was just a bump, but yet the van was totaled.
Because it was struck from behind, but that's not relevant to the bump.
But I mean, the jury heard all that.
Yes, it did.
And that would have been admissible regardless, the photo of the van.
The photo of the van and the back of Feaster's car is, I believe, is the only relevant impact. And that's the issue. Is it's not how much force was applied to the back of this van. The issue is, you ask Mr. Milburn, how hard did you hit the car in front of you? He says, I just barely touched her. Ask her, she says, it was a hard impact. Well, then we can show the jury that picture and let them resolve the dispute and say, okay, here's the front of the van, here's the back of the car.
But I mean,
was it a touch?
She did have MRI evidence to show there was injuries to the vertebrae, which was different from the one from, I think, 2002.
And what's relevant to that?
Pre-existing injuries.
And what's relevant to that, as far as her supporting her claim, is how hard she got hit. Not how hard Mr. Mahoney got hit. Not how hard Mr. Milburn got hit. It's how hard she got hit. Is that consistent with her claim of injuries? As far as, whether this was a feature of the trial. Again, counsel said, well, it wasn't a feature, it was just a small part of it. There's all this medical testimony. And the reason I say it's a feature is it set the stage for the whole trial. The very first witness called was Mahoney to talk about how he had been knocked unconscious and dragged out of the car, and showing pictures of, his trunk and his back seat and everything. The very second witness was Milburn. Again, he was asked, how hard were you hit? Never asked, how hard did you hit Ms. Feaster? Then the next witness was the police officer that took the pictures. So we get to show the pictures another time. So all of that happened before we get to the disputed medical evidence. Show all of this stuff and talk about how great all these other impacts were.
But there was no motion in limine run by the trial court ahead of time to exclude those photographs.
Yes, there was.
And the judge denied it.
Correct.
And did the judge give you the rationale for denying it? It seems to me both sides would have been forced into getting experts. If the judge says, I'm excluding it without more, then I think he says in the transcript, then we would have had a battle of the experts. And he says, I think the jury, it seems to me what he's thinking is the jury can figure it all out. Let them decide what this is all worth.
And that goes back to...
gotten an expert.
That goes back to my yes or no answer to your question. I don't think an expert is needed to have Milburn testify, I just barely touched her, have her testify, he hit me hard, and to show the jury those pictures so they can
you want us to
resolve this
rule as a
dispute.
matter of law that's all irrelevant, even though there's case law going both ways.
I don't believe it's relevant to show what happened to Mr. Picconi's car to talk about whether she got injured at the end of the line. That's nothing more than just conditioning the jury, prejudicing them to say this was an incredibly violent impact. Well, hers wasn't. And that's the only thing that's relevant to her claim of damages is what did she experience. And that's the issue that wasn't asked. They said there's all of these other things that were shown to the jury in order to inflame them. Okay. I think that's all the notes I had on that issue is, as far as the future non-economic damages, the only thing, I think it's clear. I think Manass controls. I've already told you what I believe the evidence in the record.
You heard my question.
Yes.
The judge took it under advisement. We don't ultimately know what his thinking was. He could have went back and said, maybe he corrected himself and realized this was not reversible as a matter of law under Manassas, but he might have thought, I heard all this stuff and really, it's not right. There was all this overwhelming evidence that she may need surgery, and plus getting all these needles, and she's got all these issues in the future. How can I just say the jury got it right here? I think they got it wrong on the facts. And
that's why my statement to you is that I don't believe it matters, because there's one or two options. He applied the wrong law. If we send it back and he says that, he gets reversed. If he says, I think that the jury got it wrong here because look at all of this stuff, my argument to you is, well, you can't do that. You have to look at the other stuff that's already in the record, the contrary evidence that supports the jury's decision. So if we send it back and he says, I disagree with the jury because I think all this other stuff was better, well, now he's a seventh juror with veto power, and you reverse it for that reason as well. So I think if you agree with my argument here today, it doesn't matter if we send it back and have him say either one of those two things, because the result's the same. If you disagree with me, then if he says, the overwhelming weight of the evidence was the contrary, then... If we send it back to the judge to make further findings under the rule and case law, then we're giving you an appeal, but we don't know that we're doing that, because you could be right. Maybe it was a one-issue argument, and that's all he took home with him. He never really went outside the box, but we just don't know. And maybe there was something else he can point to convince us that he wasn't a seventh juror. Well, I think the corollary to that is I've already pointed to you the evidence that I believe would not entitle him. I don't think that he's allowed to point to anything else, because there is evidence in the record that the jury could have used to reach its decision, so we have to give deference to the jury on that issue.
Thank you, Mr. Tinker.
Thank you.
Thank you both. Our next case, Winn-Dixie versus Smith.